Hi, and welcome back. Before we move on to our next topic, I thought I might just take a few minutes to discuss the ethical considerations that arise out of the use of alternative dispute resolution. Because we know that ADR offers many benefits, but it also raises several ethical considerations. And I thought we would just visit a few of those today, starting with the idea of informed consent and voluntary participation. Parties should be fully informed about the ADR process and its implications before agreeing to participate. They should understand the differences between ADR and litigation, including the potential consequences of their decision. And participation in ADR should be voluntary. Parties should not be coerced or pressured into agreeing to it. Now, in today's business climate, many companies are including arbitration provisions without providing any notice of the consequences of the provision. We've seen this with employers particularly, wherein in the employment agreement there will be a provision to use ADR, but no communication of what ADR actually means. In fact, there was a case back in 2009 that went all the way to the Supreme Court in which an employee had signed an arbitration agreement, believed later that he had been discriminated against, filed a lawsuit, and his employer moved to halt the lawsuit and force the case into arbitration. He testified that he didn't know what arbitration was when he signed the agreement, and if he had known, he would not have signed it. Nevertheless, the Supreme Court said it's incumbent on you, the signer, to know what it is that you're signing. So, yes, it is possible to force people into these arbitration provisions, but in an ideal world, we would have voluntary agreement to them. We would focus more on discussing the advantages of ADR. Another aspect of ADR that comes up is the neutrality or the impartiality of the neutral. The neutral third party must maintain impartiality through the process, and they should avoid any conflicts of interest or disclose any potential biases and ensure that both parties have an equal opportunity to present their case. I actually had a case involving a client of mine who was owned a franchise, and he got crosswise with the franchisor who took away his franchise. And of course, this is a major thing. If you're a franchisee and you lose your franchise, then you've lost all of the branding of your business. And so the client approached me. We went to court and filed a lawsuit. The franchisor came in and said, no, there's an arbitration agreement in the franchise agreement. You are bound to arbitration, which from our perspective was fine. We have no problem arbitrating. However, when we inquired as to what the rules of the arbitration were, we learned that the arbitration panel was going to be composed of other franchisees, 3 franchisees, in the same position as my client. Well, that meant the judges and juries of this arbitration are going to have an ongoing business relationship with one of the parties to the dispute. And they know what happens if they get crosswise with a franchisor. They wind up in the exact same situation as my client. Nevertheless, we lost and were forced to arbitrate as it was, and of course, the results were not good. Confidentiality, again, ADR processes often involve confidential discussions and information sharing. Maintaining confidentiality is crucial to encourage open communication and facilitate resolution, but of course, ethical dilemmas can arise when confidential information reveals illegal activities or threats to public safety. Fairness and equity is also something that we need to address. ADR processes should strive to achieve fair and equitable outcomes. I would argue that this is generally the case. As I pointed out, most arbitrators tend to pick a figure somewhere in the middle. But of course, there's always the danger, imbalances in power or resources between parties, and there's often a heavy imbalance between the parties to an arbitration agreement that can sometimes lead to unfair results. So again, make sure that the arbitrator or the mediator is aware of the potential imbalances and makes efforts to ensure the process is fair for everyone involved. Enforcement of agreements, again, in arbitration, the arbitrator's decision is almost always binding, and parties generally do not have a right to appeal. Therefore, again, it's essential to ensure that the arbitration process is fair and that the arbitrator's decision is based on sound legal principles. Once upon a time, one could bring a claim saying that the arbitrator had exhibited a manifest disregard for the law, but again, the Supreme Court announced that this was not a valid objection to arbitration, and therefore we are left with a situation where an arbitrator could theoretically go out and find something that no reasonable person would do, and yet we're bound to the result. Access to justice, we need to make sure that ADR is accessible and affordable, and while that is true, it may not be suitable for all disputes. Again, arbitration can be a very efficient means of resolving a claim. Nevertheless, those parties who don't have the resources to hire an attorney or a law firm to assist them could find difficulty taking advantage of the ADR process. Transparency and accountability. ADR processes obviously can lack transparency. This is one of the drawbacks to ADR, is that the world doesn't learn about what's going on. All of the information relevant to the dispute is kept within the circle of confidentiality between the arbitration panel and the parties. And this can raise concerns about accountability and the potential for abuse of power. So therefore, it's crucial to establish clear rules and procedures for ADR processes. Now, addressing these ethical considerations requires a very thoughtful approach to ADR. Educating the parties. Ensure that the parties understand the ADR process, what their rights are under the process, and the potential consequences of their decision to go through the process. Selecting qualified neutrals, choosing neutrals who are experienced, impartial, and committed to ethical principles. I once inherited a case that another attorney in my firm had been working on, and he had agreed to an arbitrator who was probably the worst possible arbitrator for our type of dispute, and we had the outcome that you would expect with that. So very important to not take this step of choosing your arbitrator lightly. Establishing clear rules and procedures. Again, make sure that there are rules and that everyone knows what the rules are. You, as a future business manager, should also monitor and evaluate your ADR programs. Make sure they are doing what it is that you want them to do. And if they are not, then either improve them or revert to litigation. So in conclusion, what did we learn today? ADR offers many benefits, but it also raises several ethical questions. Addressing these ethical considerations requires a thoughtful approach to ADR. And that's it for this one. Thanks a lot for listening. If you have any questions, be sure to let me know.